Pronouncement of judgment, Writ Appeal 161/2025.
Type A for little accommodation in respect to item number 19 loss. With the consent of my senior sister loss.
19.
19 loss.
You are
Here
asking
also
for adjournment.
Here also I have to file affidavit. In the note loss, we have written the date mistakenly also. From accommodation loss.
You are appealing the matter.
Yes, your lordship.
When do you want?
Any day loss, within after 1 week loss, after 1 week.
Look at your calendar. Take a place a date.
November. 3rd of November loss.
3rd of November. Okay.
Yes.
On the prayer made by Mr. K. Gogoi, the government advocate, the matter stands adjourned today. Ms. G. Goswami, the counsel for the respondents.
Yes,
All the
number
private
one.
respondents. Number one.
Number one, yes, sir.
Private respondent number 1 is present. Next para, list on 3/11/2025.
Loss.
Obliged.
Obliged loss.
Lord, item number 11 may be upgraded, madam.
Oh, we have very less matters today. We'll try to take up.
Worship, I'd like to mention item number 15. With the concern of others, that only 1 week time may be granted.
Just.
My lord, I am in the other side. We have
Just
some
a moment.
urgency matter is pending since last 1 year for
Just
order.
a moment. Item number?
However, on next
15.
week,
Just a moment. I
15.
have not heard you. Just a moment.
15, 1/5.
15.
Yes,
It's a review matter.
review matter. Actually, my senior AK Bhuya has been recently engaged as a standing counsel of BTC. And we have received the files yesterday only.
Okay. Since Mr. Mahmood is objecting to the
No,
adjournment,
so-
we give a short date.
yes, yes. 3rd November, my lord.
Review petition. Both sides are represented. On the prayer made by learned standing counsel for the BDC.
No.
Matter stands adjourned today.
No, 3rd November.
Next para, Mr. M.U. Mahmood, learned counsel for the petition, expresses some urgency in the matter. Next para, list on 3/11/2025.
Obliged. May it please your lordship. Lordship, I beg to mention item number 10 for adjournment. Lord.
This 10, there is adjournment slip. Both sides are represented. On the prayer made by learned counsel for the petitioner, matter stands adjourned today. List.
Any date, lords. After 2 weeks, lords.
List after 2 weeks.
Prayer for
applies.
listing of a matter.
Just give it to the court master.
Prayer for listing.
Give it to the court master.
For delivery of orders, supplementary item 24 with 25.
in this matter, we have distinguished between two terms, that is deportation and expulsion. And we have said that it cannot be interchangeably used. And insofar as the declared foreign national in this case is concerned, is facing an expulsion and not a deportation. And accordingly, the state has a right to take steps for expulsion from the country, and accordingly, this writ petition is dismissed. We have observed that the state shall take steps for expulsion of the declared foreign national from the country. There will be some delay in uploading because last moment we have seen few typographical errors which have crept in. So by afternoon, it will be uploaded.
Apply the law.
Daily list item 1 for motion.
This matter, the loss of the petitioner had expired on the year 2021, and we are the newly engaged counsel in this case. It has been not been informed to the court.
We are not getting it. Please say it again.
The petitioner in this case expired in the year 2021, and it has been not been informed in the court. They have engaged counsel was being informed,
Okay,
so we may be allowed to file a substitute petition.
okay. So we adjourn the matter. Mr.
Yes, Ahmed.
S.
Ahmed.
Learned counsel for the petitioner. Learned counsel enters appearance on behalf of the petitioner and submits that as per instructions received by him, the petitioner has expired in the year 2020, 2021, which was informed to the learned counsel on record. Full stop. He prays for an adjournment so as to enable to obtain appropriate instructions and to take steps if so advised. Accordingly, the matter stands adjourned today. List on, give a date after 2 weeks. 2 weeks would be sufficient.
Yes. Much of the.
Item 2,
The respondents of counsel.
May I please also. Also, this matter ought to be listed in the admission column also. And the TCR has not been received. Notice was already issued.
You were there when the matter was heard.
Yes, yes.
This writ petition is already allowed. It has come here just for default. There's an order to send back the records, but the records are not called for. Your writ petition is allowed long back,
That-
3/6/2024,
This number is what, Lordship? That number is
2824.
2824 was allowed, Lordship, and I have appeared there, expertise was vacated, and another writ petition is pending, Lordship. I thought that writ petition has come up.
I don't think we have numbers here in the cause list.
And that, Lordship,
This, both sides are represented. This writ petition has been allowed by order dated 3/6/2024. Next paragraph, however, the matter is listed in view of the observations made in paragraph 17 of the said order to, directing the registry to return back the records. Next paragraph, as per the office note dated 17/8/2024, the records were never called for. And accordingly, the matter is placed before the bench. Next paragraph. As the records, as it is noticed that the records were never called for, and the writ petition was allowed on the at the motion stage by order dated 3/6/2024, there would be no requirement for the registry to return the records in terms of observations made in paragraph 17 of the order dated 3/6/2024. The said order dated 3/6/2024 passed in this writ petition stands. Paragraph 17 stands modified in terms of this order. As per this order shall be read together with order dated 3/6/2024 passed in this writ petition. Writ petition is disposed of in terms of order dated 3/6/2020. Currently disposed of. Yes, item 3.
Your report was for me.
Yes, you got the.
Okay, fine.
Got the.
oh, you know what? Talking about it.
He said that when police recovered the although they have left of the police recovered. It kept engaged, but till date, there is no any clue or lead to find out. the
Are you
cause.
prepared? Can you tell us what can we do?
Alright.
My lord, although it is from unreliable source, lordship, the petitioner intimated me, lordship, that accused person, lordship, sold her, lordship, to somewhere, lordship. although it is from unreliable source, lordship. So if,
No, you'll have to bring this on affidavit because you see, otherwise it becomes very difficult. There are two things, please understand.
yes, lordship.
This court is not monitoring the investigation.
Yes, lordship.
It is only when this criminal petition has been filed that we are trying to find out the body.
Yes, lordship.
But
So it is the failure on the
in
part. of the-
this, in this, we have very limited role except for a direction to produce the,
Yes,
but if they. Well, that's why we are trying to understand from you as to what would happen if the, if after investigation, person is missing. What can the court do? You just want to understand, there may be some authority on the point
yes,
where it has been held that these are the steps which could be taken by the court when there is a direction. You see, the dead body is not found.
yes.
If you make a statement that she is alive, then the case would continue as a missing person.
Yes, lordship.
And the only thing which we can, with a limited what you call understanding, is you see section 108 of the Evidence Act.
Yes,
I'm not very acquainted with the new one. Will give 7 years time for the closure report to come.
yes, lordship.
It is in that legal aspect of the matter that we are asking you.
But the
We really
police-
want your assistance to understand the law in the matter as to how the court can monitor an investigation where the person is missing and no trace is found out. Because first the allegation is that the woman must have been burnt in the brick field.
Yes,
That is what our first impression was also there.
Yes.
That perhaps there has been a sexual assault and thereafter she has been burnt in that brick kiln, and we have, on the last occasion, we have checked up. The temperatures would rise
Yeah.
for more than 600, 700 or 1000 degrees in a brick kiln. And with that amount of heat, the remains of the dead body will not be there.
Nothing is very much.
But that is only our research in the net. We don't know. We don't have the authentic.
Nice.
Ms. G. Baran and counsel for the petitioner. And you said both sides are represented. Although the records of the tribunal was called for by order dated 10/3/2021. Okay, and requisition to that effect was sent by email on 19/3/2021. Some of the records have not been transmitted. Which page is the opinion?
13, your lordship. Starting copy.
58,
15 is the order, your lordship, opinion.
page,
15, your lordship.
15, okay.
15 is the original one, your lordship. The titling is the 13, your lordship.
21/7/1988.
No, I'm searching for the case number, that is
FT case number 987, your lordship,
9087.
in 1987.
In bracket, lordship. Top.
No, whether it's right or wrong, because normally our requisition are honored by the tribunals.
Yes.
If it is not coming, we are asking why. We are thinking, trying to find out why.
Ninety this one.
This will be where now? This record will be in tribunal number 1. Nagaon has several tribunals.
Several
Yes,
levels,
Lord Chief.
which is
Maybe at tribunal number 1, Lord Chief.
Tribunal number 1.
One.
Coordinate tribunal number 1. Nagaon. We're sending a requisition through email at the following email address of the said on tribunal. Next para. List on 17/11/2025.
Item 8.
Yes, Mr. Mishra.
In this case, my lord, one report was called for. Remember,
Refugee registration.
report from the Nagaon DC office was called for regarding the document, my lord.
Refugee registration. Sharma.
Yes, Lord Chief, I don't have the written instruction, but telephonic instruction I'm getting, Lord Chief. They could not find the record, Lord Chief.
But then they'll have to send a report. But then we'll have to examine and pass orders.
Lord Chief.
Because this was the case where we had referred to that 1947
Yes, yes.
rehabilitation.
Certificate was issued in 1953. And it was said that it is not found.
Because you see, this department existed.
Yes, Lord.
So it is only the appropriate authority who can now tell us whether the document is fake or not.
Yes, Lord.
Somebody must be the custodian of the document, even if this department is no more there.
Yes, Lord. On this point, my lord, other 2-3 cases are also pending from the court, my lord, tribunal, my lord. I can give a number.
No, not that. First of all, in your case, we can get the
Yes, my lord,
records.
that is
For other cases, we'll worry when those records come.
no, my lord, in my case, one case record was mentioned. And in that, there was, against that order, the person came to the court and got some orders from this court, but it is not. listed to them.
Lordship,
Will be the competent authority to tell us where this department
Lordship,
are? Home, it
because-
will only be home.
because DC and a concerned SP has told that Lordship, there is, they could not find the record, Lordship. So,
You see, they will not be the persons who will find the.
yes,
records.
yes, Lordship, pro Commissioner and Secretary, Home and Political B Department, Lordship, I can get the instruction, Lordship. They are written instruction.
Lordship, the case number name is Nibaran Mondol, my lord, which is in my case, they have relied on, my lord. Here, my lord, notice was issued and posted for hearing, my lord.
Who's the CGC today?
Yes, yes, yes.
Is that? Give us call for DJ Das. CGC. Just wait for some time.
Yes, master.
RK Devsudri maybe, call Lordship, he will, I think Lordship, he will be better person to get the
RK
instruction. RK
Devsudri.
Devsudri.
No, whoever the CGC will tell him, they will communicate. Yes, item 9.
May I plead the lordship? The matter pertains to custodial violence, your lordship. The petitioner before your lordship is the wife of the victim. So on last occasion, the case diary was called.
You know that?
Yes. Well, the case diary of Bokota Nemoguri PS 12 of 24, I have received.
Yes, Dr. Nemoguri.
Yes, ma'am.
We are called for 2, 11
Well,
and
the
12.
11, malad, is a case in connection with which the petitioner was taken up by police. That case diary, malad, I have not received.
You can get scanned copies. Now we don't need the, because otherwise, in the name of perusal of the case diary, the investigations are stalled.
And this is malad the case after the incident, police has registered a case and it was ultimately investigated by the independent IO. That diary we have received.
If any ballistic report is there, your lordship, it will be required.
Very good. New product.
Mr. Nath,
Yes.
would like to press the case diary. You can have a photocopy made and give it to the court master. Send back the case diary.
Lordship.
We'll want to read it.
Lordship.
Lordship,
The-
apart from the case,
The armory report is not there of the,
But the, kindly see the Lordship, page 33. Pencil mark pages are there, no?
yes.
Page 33. That is the list of exhibits sent for examination. The 9mm pistol of the OC, it was used. One round bullet was used, and that was, my lord, seized. And the 7 rounds of live, the remaining, those are there, my lord. And those are sent for examination. my lord.
your lordship, ballistic report along with the trajectory report will be required, your lordship.
And photograph is there, my lord, at page number 18, my lord.
No, photographs doesn't give a very clear picture.
Injury, my lord, the second photograph, my lord.
No, injury is okay, but we are more interested in the,
Lordship, moreover, lordship will kindly come to page number 90.
One bullet injury just above the knee.
yes, what you saying?
Lordship, page number 91 of the affidavit filed by the respondent number 1 to 7, your lordship. Whether the ministerial inquiry report is complete and it will be reflected, your lordship. Page 91.
Mhm.
Page 90. Lordship, got it?
Yes,
In the procedure adopted, your lordship, lordship will kindly come to point number 4, FIR and GD report analysis of FIR and GD report. This is not there in the inquiry report, your lordship. Whether the inquiry report, ministerial inquiry report is complete or not. The inquiry report is submitted only with the,
you see, we can't just find small faults in the police report and our ministerial report and then start the adjudication. You see, now please tell us, you have some experience in the bar. Please tell us, how would you analyze a GD entry? What is so great in or effort taken for analyzing a GD entry? Let us say there is a GD entry. I'm telling you because this is a GD entry we have found that at so and so time, so and so, a cow entered the office premises and and has eaten a particular file, part of a particular file. This is something I have read. Now this is a GD entry, and accordingly the Chowkidar reported to the police by phone, and therefore we have recorded. Now this is a GD entry. Please tell us, how would you analyze it?
but your lordship, in this case.
We understand this. So you're asking a question for a particular purpose. Question may be unnecessary, or according to you, it may be what do you call inappropriate.
Mm,
But please tell us in analysis of an FIR or a GD entry, what do you analyze of this GD entry? Or say a GD entry that today a dead body was found at near the High Court premises today at 8:30 a.m. This is a GD entry given to the police. Telephone by ABC, telephone number so and so recorded. OC to be informed accordingly. This is the GD entry.
Okay.
Now, please tell us what is the analysis and how did it influence the court in taking a decision? So FIR. So
Lots of-
FIR, if an analysis would lead to some consequence, then we understand. Otherwise, in the material, they said that, okay, analysis.
That's it. My point is that whether there was any GD entry or not regarding the firing. Because the ministerial inquiry was submitted only by recording the statement of the witnesses. 12 witnesses, 3 are family members, 2 doctors, and 7 are the same police officials who were involved in the crime. And nothing else, no trajectory report, and the ballistic report, you'll all say. And whether there was any GD entry regarding the firing.
What was the date of the incident?
Incident took place on, let's say,
16/10/24.
16/10.
Page number 51, GD starts from.
16/10/24.
16/10.
16/10, page 51.
51.
Page 51.
There's something wrong. 51 is a medical.
But kindly take pencil mark page. Pencil mark page.
Oh, it's you are.
It is GD. It is GD.
Okay.
Any case there.
GD entry.
Lots of. Page 55 is the second GD at 3:30 hours.
Show it to. Show it to her if you have a copy. You have a copy, no? Acha, you have that. Okay.
Fifty-one to that. That pencil already page mark करेंगे 51 to 51. No,
Mr. Hussain will tell you something.
Okay.
Normally, a police, it doesn't require too much of effort. Normally, a police will record FIR in respect of a crime.
Common council is there.
But when the police has shot a person and they say they have, the person was running away and therefore he was shot.
No, sir.
For that, the police is not going to register an FIR. But you see what has happened, 2 things has happened in the meanwhile. Number 1, a bullet has been fired, which is a government property. And therefore, under the requirements of the human rights directives of the National Human Rights Commission, coupled with the directions contained in the case of DK Basu, the requirement is that that has to be recorded. So the recording is done by way of a GD entry, and it will always be there. When it is a person who's been shot, and the police people will come and then record it, bringing it on record. Otherwise, they would face very serious consequences. There are directives of the Supreme Court after the human rights directives have come for recording of the FIR. There are 3 or 4 3 cases, in fact, prior to 2000 about the requirement when there is a death or shooting by a police, an injury. So those GD entries will always be there.
Yes, yes.
So it doesn't take much effort. It will always be there. But let us see the records. You can have it, we'll send it back.
Yes, we'll send.
You give a copy.
Yes, sir.
You can give it by Monday and we'll fix the matter on the next week.
Lodge.
No, we don't need it.
Okay.
You keep it with you.
Right.
Because, did it.
We'll have it next week. In the meantime, on Monday, you can.
On
give a
Monday, by
photocopy
Monday,
To the
we'll,
court master, you can give it.
Lodge, we'll provide. Lodge.
So that we can read in the meanwhile.
Yes, yes.
For the next day.
Lodge.
Lordship,
The original copy,
So he's trying to say.
one
original-
point, Your Lordship, our contention in the writ petition is that how one bullet injury has led to the amputation of the leg. And our contention is that I am not,
Yes.
we are not running away.
See, that is something which you'll have to read and then come to a
That's right.
finding.
Not for
For
that,
one,
Your Lordship, whether the.
see, Ms. Hussain,
Also,
by now you have, you must be knowing that I have some interest in medical,
Lordship.
correct? You want to, if you have time today, I'll send you to meet a person who had a very simple accident. A scooter came, auto rickshaw came just near the Patasi Lambari bridge, hit the rickshaw. This man fell down from the rickshaw and by the evening of the same day, his hand had to be amputated.
because of.
No serious injury. He just hit. He also did not understand the gravity of the injury. It is the people who took him to the hospital, and in hospital he went without what you call office, not out of anything but compulsion, because the people took him there. And by evening of the same day, his hands were amputated. You want to meet the man? You are asking us how one bullet injury can lead to an amputation.
Lordship, because there
We
is.
know of cases where even without a massive injury, without bullet injury, even a small accident may lead to amputation.
But in this case, Your Lordship, there is a time interval of 3.5 hours in crossing 65 kilometer, Your Lordship. How it took 3.5 to 4 hours to cross 65
You
kilometers.
have been in traffic in Bangalore?
At night, Your Lordship,
No. You see, those are things which are not within our. It's not beyond the scope of adjudication.
because I am on that because of profuse bleeding and negligence of the police officers.
We can't comment.
Also.
This is something beyond our comprehension. We have not even read the case diary.
Because everything is revealed by the doctors also, Your Lordship.
Ms. Hussain, there are few things we have no answer to it. Have you accompanied any patient to any hospital?
Yes, Your Lordship.
Yes. Then tell me a standard operating protocol for a person who during emergency is taken to a hospital. Can you tell us?
Only that ambulance siren.
No. First, a man is taken to the hospital, and if he is not accompanied, is not on the recommendation of any doctor, he will be first taken into casualty.
Oh, yes, Your Lordship.
In casualty, it may take you some time for the doctors to come, have investigation done, and then the real specialist would be called for. And I am saying so because I have some experience. Even with my my status, when I had to take a patient to an hospital, we had to wait in the casualty till these casualty people would examine and then say that yes, he is fit to. This is this problem diagnosis made, and therefore he goes to that department. Now, can I say that I am more important than any other person so that I would get a priority? In the hospital, when I went, I didn't even, except in the later part of the day, nobody even knew of my identity. I was just watching things happening. And the person who was hospitalized was my aunt. Now she's aged 75 years. She fell down, had a fracture. There are no answers to everything. Are you aware in Europe, what is an average time if you have a requirement of having, say, supposing you have a pain in the hand, you want to get yourself examined by a radiologist. Can you tell me in Europe, entire Europe, what would be the average time taken for a person to have his hand x-rayed?
No idea.
No. It may take 1 to 6 months. How much time it will take in Europe for having a dental issue resolved? People would come to India and do it. I have relatives outside. If you have a problem, it's a usual protocol in Europe. In many countries in Europe, I'm not saying of every nook and corner, but many countries in Europe, where you'll have to go to a particular doctor of that locality. That means, High Court is in Uzan Bazar. Only a doctor of Uzan Bazar can see you. You can't go to Guwahati Club and get yourself checked up. Doctor will not check you. After that, he will make a recommendation, and then you are in a queue to have testing done. My son is in queue for last 6 months. He's coming to India next month to have his regular checkup done. And by that time, if Mr. Abedin's daughter becomes a doctor, I will be happy. Correct?
Huh?
You will have it all checkups and then go again.
It's easier. It's easier, I can tell you. So we have no answers to everything. And we are still better. With all these handicaps, we are still better. We are not dismissing our matter. We are just wanting to really have a knowledge of the FIR, the case records.
But in this case, as they are only the witnesses are the same police officers, whether a trajectory report will be required, Your Lordship.
We'll see that. Unless we know what is there, how can we predetermine what is be required?
Also.
You want us to go through the records, or you don't want us to go through the records?
If it can be called.
We don't know what is inside. My esteemed sister has vast experience in dealing with these matters. So please let us go through the record and then we'll. Senior committee appearing for the state respondents. Next person. The learned senior committee advocate has produced the case diary. Next person, the same is returned back. So as to enable the learned senior committee advocate to make photocopies of the case diary and to hand it over to the court master for the perusal of the court. And for full stop, the original case diary be returned back for expeditious investigation. Next para, list on. Says the date. Say the date.
Can it be on 4th one?
4th November. Okay.
Lordship, after third week, Your Lordship, November, some difficulties.
After 3rd week.
Yes.
Says the date. Give a date. Is the calendar is there?
Any date, Your Lordship, after third week.
Okay. 25/11/2025.
25, lot.
just before that you say, if
25 Monday, Monday,
in the meanwhile, the learned senior government advocate shall interact with the OC and, sorry, the IO of the case and have the updated status of investigation. We are not saying it, but you take note of that. She's referring to trajectory report and the
Logic.
forensic reports
Yes,
to be produced from the next date of this list transparency.
Mal.
Deeply obliged.
Time being item 8.
I'll keep the photocopy of the CD and the original I'll return.
Yes, already.
Logic.
And sorry, this one more. In the meanwhile, the case diary of
Bokota Nemoguri 12,
what-
1224.
see the last order, huh? Bokota Nebuguri, case number 11, PS case number 11 of
12, this is 12.
this is 12, so we need 11
11 I will.
of 2024.
Yes,
Okay. Just a photocopy of the scanned copy.
kindly
It
see
is a-
scan code, logic.
Photocopy of the
I'll,
scanned
I'll,
copy.
Scan code.
Yes.
May please, your
we
lordship.
required you.
Lordship.
You see, there is a authority which was called Rehabilitation Department,
Lordship.
and they were for the resettlement of displaced person who had migrated from Pakistan. And Mr. Vishwa holds a copy of the refugee certificate.
1953.
Yes. Now, the deputy commissioner doesn't say it is fake, but it's not being located. So you'll have to tell us, find out and tell us who will be the authority who would now be holding records of this rehabilitation department.
Lordship.
Mr. Mishra, you please give a photocopy to,
Yes.
I'll get the instruction on the next schedule.
which page is that?
But Lordship wants to know, Lordship, if it's
No,
not
we'll
the
have to
DC,
call that record.
Lordship, if it's not the DC, if DC doesn't have the record, then who has the record?
Who has the records? Because this is, this rehabilitation department is something which is created by the government of India.
Community, yes, Lord. I think it's something compensation at the rehabilitation department, I think.
Page 48,
Page?
48, just Xerox copy
48.
and the type copy is 47.
Just give this
Yes,
photocopies to
I'll provide.
Mr. Dats. Or rather give, or rather give, you have a copy of the reputation with you?
Lordship,
You have a copy of the reputation with you? No.
Lordship, I'll get the copy, Lordship, I have the
Give a
copy with me
photocopy.
now. Doesn't.
Also as a representative. As next, the Learned Standing Council for the FT and Border Matters has submitted that the information regarding the refugee registration certificate within bracket Annexure 7A, page 48. This is within bracket. Could not be received. So we place for some more time to get the information from the Home and Political within bracket B, bracket close department. As suggested by the court. Next paper. Mr. M.K. Mishra, Kumar, and counsel for the petitioner shall provide a photocopy of the writ petition to Mr. D.J. Das done at CGC so as to enable him to obtain information from the competent authorities in the Government of India
Under the Ministry of Home Affairs, Your Lord.
under the Ministry of Home Affairs for getting information as to who would be the authority, who would be holding the records of refugee registration certificate referred above. Next para. The learned standing counsel for the FT matters as well as the learned CGC shall send a downloaded copy of this order to the competent authorities to obtain information. List on, yes, when,
After 2 weeks, your lordship. 2 weeks, your lordship.
after 2 weeks. List on 17/11/2025.
Most approved.
Item 11.
May I please, your lordship? Lordship, on 15/9,
I received my lord that order. Passed by the advisory board.
but on last occasion, they were supposed to file affidavit in this regard.
No, not
And my lord,
earlier I have filed affidavit. That is my lord.
even on
report of
15/9,
Advisory board, my lord.
15/9 also.
Passed order. The representation already disposed by the advisory board. তোমার উপর দেওয়া হয়েছে আমি আমার পক্ষে করতেছি
Well, on last occasion, over phone, they took instruction that order has been confirmed by the advisory board. And in this regard, they were supposed to file affidavit today, but and in this regard, they took one week extra time. So my lord, till now, we have not received any affidavit, lordship, in this regard.
Affidavit,
And
I have-
apart from this, my lord, advisory board passed this order, confirmation order, without application of mine, my lord, because there was no representation from the detainee side,
তোমার নাম আছে
and without considering detainee's representation, the order, confirmation order was passed.
কিসে advisory board তোমার তো দেখাই দিয়েছে এটা তোমাদের ইনস্ট্রাকশন করেছে সেন্ট্রাল গভর্নমেন্ট
Because my lord, as on date, 136 days behind the detention. And my lord,
মনে দিয়া কই দিয়া এটা কোন দিয়া এটা কোই এটা কোনে ভালো
my lord, apart from this issue, advisory board issue, ground, my lord, I have compiled some other grounds. Yes. Yes. So my lord, they were supposed to file affidavit today regarding this issue of confirmation order from advisory board. And in this regard, my lord, advisory board passed that order, confirmation order, without application of mine, because my lord, that representation filed by the detainee was not placed before the advisory board and was not considered. Without considering the representation, the order was confirmed.
Is your submission in, is on strong legal footing?
My lord, apart from this, there are other grounds as well.
You made a submission. We are just asking you whether your submissions is in a sound legal footing.
Yes, my lord.
Yes.
My lord, they have placed this order, order of confirmation from the respondent number 2, dated 4th August 2025. And this is the order from the government. There is no order they are placing before your lordship, that advisory board's order. We have not received that. They have not provided to the detainee also, lordship. So in this regard, if they file, they would have filed affidavit, then all these things would have been cleared.
Yes, this is very serious. If you have not given copies of.
Well, yes, in this case, everything has been done by the state government. And the detainee has not submitted any representation to the central government. They are not, not submitted, not filed any representation to the central government. Madam.
It's not required.
Yes, not
Not
required.
under the act, if one authority has received, it is their duty to
Yes,
give it
yes,
to you.
the appropriate authority. And now the confirmation
If the
order
Home
is
Department has-
of 4th of
If the Home
August
Department has not
25.
sent it to you, then this order is required to be passed. That's,
No, no, madam. Detainee has not filed any application. That is not required, but they have sent a copy of this order, madam. They have sent. And that order of confirmation passes in 4th of August 25. Within due time.
you see, this will not deter the court from passing any order. If you have not served the copy of the confirmation order and the copy of the advisory report, board's report to the detainee.
Yes.
But that the state government will. Has to do
Not
that.
there, it's not there. We just pose a question that this has not been done and no affidavit is filed. If you don't do it, law will take its own course.
Original record has to be, otherwise we don't know.
My lord, my lord, in this-
Because every time we will not tell you what to bring. Original records is right. You have to bring the original records.
No, my lord, two things is not clear, and in this regard, I'm setting one order passed by your lordship.
It's okay, we have to give them an opportunity.
Since 15/9,
We'll take
my
it up
lord.
next week.
order was passed to file affidavit on 15/9.
We have
And
seen that.
since then, it took almost 1 month
Already
in a
one-
habeas corpus matter, lordship.
Already one affidavit was
And
filed.
even in last
We
occasion,
don't know,
lordship,
it's
my
your
lord,
call, we don't know.
my lord.
We take record of the law and then pass orders.
The report is necessary, no?
You are Mr. M. Rahman. Your name?
M. Rahman.
Mr. M. Rahman, and counsel for the petitioner is present. Mr. P. Sharma, an additional senior government advocate, has produced a copy of order dated 4/8/2025, issued by the Secretary to the Government of Assam, Home and Political Department, thereby confirming the detention of the petitioner, namely Siva Bhuya, alias Sujal Bhuya, for a period of 1 year from the date of detention on the basis of report of the advisory board dated 29/7/2025. Next para. Mr. K.K. Parashar, learned CGC has submitted that as per instructions received by him, the petitioner has not submitted any representation to the Government of India. Next para. The learned counsel for the petitioner has submitted that as per the despite yes, which order you are referring to, Mr. Rahman?
My lord,
Which order you are referring to of this court?
my lord, 5/6/2025, it's on page number 15.
5,
5/6/25. 5th June 2025, page number 15.
no, about that affidavit.
Affidavit we have already filed. What affidavit?
No, affidavit, they have not filed, my lord.
SP affidavit.
From the respondent number 2, no affidavit is filed till today. Only the superintendent of police Vishwanath has filed one affidavit
Perhaps
that we have received.
Perhaps 1710, my lord. Earlier order 1710, my lord.
1710.
17. 1710, there is no order.
Submitted that despite order dated 1/7/2020. Sorry, 1/9/2025. Except for respondent number 7, no other affidavits have been filed by any other respondents. Post of it is also submitted that as per instructions received by him, neither the confirmation order, the order of confirmation of detention dated 4/8/2025 or the report of the advisory board dated 29/7/2025 has been served on the petitioner. Next, for the Leonard's additional senior government advocate shall take note of the said submissions. Next, para. Last opportunity is granted to the state respondents to file their state respondent, except respondent number 7 to file their respective affidavit in opposition. Pending which the matter would be heard on the basis of materials available on record. The affidavit shall be filed at least 2 days prior to the next date of listing. Next, para list on
My lord,
this.
but in this regard, my lord, I'm relying to orders. One was passed by your lordship in Poonam Diana Devi. I have placed before your lordship, and
Are
other
you,
one is,
are you making your submissions for, are you arguing the matter or you are
my
you are
lord,
doing what?
my lord, arguing because, my lord, apart from this issue, advisory board issue, there are other grounds which are strong grounds I'm taking, my lord, and those were not complied, those were not fulfilled. That is why
If you argue on merit, please argue on merit. Then don't tell us that the affidavit is not filed.
but that
We
is
gave you
what,
an opportunity.
my lord,
But you see, piecemeal hearing, you want us to do piecemeal hearing, one part today, one part on next date of listing. You want us to hear in part?
no, my lord. What I am telling, my lord, that apart from these issues, my lord, I have compiled all total 12 grounds, my lord. And apart from these advisories, no, they have failed to file affidavit. And in this regard also, lordship, I am relying to.
What do you want us to do?
My lord,
What order should we pass today?
it's a-
No, tell us.
Otherwise, my lord, I prepared.
Then argue the matter.
Yes, my lord.
Argue the matter if you are prepared. Then don't take the ground that the affidavit is not filed.
But that is one another ground. Amongst the grounds, okay, this is one ground.
You make your submissions, please don't waste the time of the court.
Okay,
But to make submissions, start.
my lord. My lord, I have compiled some grounds and placed before your lordship for ready reference that this ground number one, my lord, that non-application of mine by the detention authority, lordship, in what happened, my lord? The detention authority has relied that two cases, two FIR, lordship. In both the FIR, my lord, lordship will notice one thing, that in first FIR, that contraband seized was small quantity, the maximum imprisonment is of 6 months. And small quantity that was not to recover from the possession of the detainee. That was recovered from other person. And the statement, confessional statement given by the prime accused, I was taken into custody and I was on bail on that first case. Then the second case registered, that was the intermediate quantity. That was also, my lord, no contraband was recovered from my possession. It was purely recovered from other person and I was arrested based on the confessional statement made by the prime accused. So in this regard, my lord, I'm relying on Apex Court judgment, my lord, the 2024 SCC online SC 3803, Karan Talwar versus State of Tamil Nadu. And other one is 2018 8 SCC 271. Both I have placed before your lordship. In Karan Talwar, relevant para is para 10, my lord. My lord, my contention is that in a situation, my lord, where accused is arrested under suspicion of involvement on the basis of statement made by the co-accused, an accused cannot be held guilty or cannot be assumed guilty under section 23 of Bharatiya Sakshya Adhiniyam 2023 or section 25 of Indian Evidence Act, my lord, without substantive evidence. So confession of co-accused cannot be the sole basis of conviction or substantive piece of evidence without corroborating evidence. So my lord, in both the case, what happened? Charge is not yet even framed in both the case. And no contraband was seized from my possession. It was seized from other co-accused, prime accused. So my lord, in such situation where charge cannot be framed against me without corroborative evidence, how, my lord, PIT and DPS can be arraigned against me? That is my humble submission before honorable court. So my lord, in this regard, I am relying this judgment, my lord, Karan Talwar versus State of Tamil Nadu. My lord will find it para 10. May I read, my lord? Para 10.
Don't read it, we don't have that much of time. You just refer to that paragraph, that's okay.
Yes, my lord. Then other one is, my lord, Surender Kumar Khanna, that is 2018 8 SCC 271. Relevant para is 10, 11, and 12, my lord. Then my second ground, my lord, I'm relying. So, my lord, my second ground I'm submitting, my lord, that as per section 3, subclause 3 of PIT NDPS Act, my lord, the ground of arrest must be communicated within mandatory period of 5 days.
Whether you are testing our patience or you are making your submissions with full sincerity.
My lord, for the sake of justice, I'm making submission. my lord.
We are just asking you, you see, we are not making any harsh statement. We are just asking you, are you testing our patience or you are really submitting on merit? The first case you have cited is a case of where arguments were made for discharge. And against the order of discharge, matter went to Supreme Court. And then for the purpose of appreciation of the matter, the Supreme Court refers to the observations made in paragraph 10. How it would connect to the preventive detention case?
My lord, correction is that, my lord, as per section of 23 of Bharatiya Sakshya Adhiniyam, my lord, that part, my lord, that without corroborative evidence, my
want
lord,
in-
confessional
in-
statement made by
In this preventive detention case, you want us to appreciate the evidence.
No, my lord.
That is your proposition.
No, my lord. In my case, what happened, my lord, charge is not yet framed, my lord, till date. So that is my one ground, Lord, sir, regarding that confessional part, my lord.
Which is the authority on the point that unless a charge is framed, PIT NDPS cannot be invoked?
Oh, no, my lord, that is not there, no bar is there, but.
That's why we are asking, you are
Yes.
testing our patience?
No, no, my lord.
We'll
In
take it
my
up
case-
after 2 weeks. Don't ever make that. Don't test our patience.
No, my lord, actually this one ground one, but other grounds, lordship, like lordship,
I know I have come with a prepared speech. You want me to deliver that speech now? It's a 2-hour speech. Tomorrow I have to deliver. I prepared a speech. You want us to read it now? It's not that once you are prepared, you will argue the matter. You argue on the basis of the point which is relevant. How would a discharge argument be applied in a case of PIT NDPS?
my lord, then my
How
lord,
would the evidence be appreciated in the preventive detention cases?
my lord, my specific ground, my lord, ground number 2 and 3, because this was missing. And my lord will see just second page.
No. Don't wait. Don't wait. Once you do it, we are not in a mood to hear you.
My lord, then fix the date, my lord.
It doesn't take you anywhere. We are ready to hear you. That doesn't mean that you will hear everything that you submit. John, you asked for the first time, you asked for the affidavits. When we are dictating the order for affidavit, you say that I have prepared on merit. We start hearing you on merit. And then you are testing our patience. Because when you made us read this paragraph 10, first thing in paragraph 10 is that the offense is consumption of narcotic. This man was having a farmhouse and there he was distributing this narcotics for the invitees to have. And therefore they were charged of consumption of possession and consumption of narcotic drugs. This is not a case of PIT NDPS. PIT NDPS was never applied here.
Regarding.
And if you want us to examine the, if your argument is that we should examine the evidence when charge is not framed, we'll deal with that. If you want, we'll deal with that argument. Now please tell us, you have a choice. You want us to deal with that argument or you want to have it some other day?
My lord, other day, my lord. The date may be fixed, my lord.
You're fixing a date. Just last order we had, huh? They would say fix on 6/11/2025. That this copy of order dated 4/8 is made a part of the record. Item 12.
Lord, in the earlier occasion, TCR has called for LO3. Let us come.
These records have come. What is the best document you have to connect you to your projected parents?
My lord,
What is the best document you have to connect you to your projected parents?
Total list of father, grandfather, your lordship is there.
Do you have your name with your father or
No,
grandfather?
no, your lordship. Petitioner is an illiterate lady, your lordship. He was given
No,
in
that's
marriage
why-
at the age of
how do you
17
connect?
years, your lordship.
How do you connect yourself to your projected parents?
DW2 evidence, your lordship, and
Who is DW2?
DW2 here, your lordship. Page 63, your lordship,
63.
63 to 68. Annexure number 17. Abul Kalam.
Where is your written statement?
Information I'm showing. Page 58, your lordship, 58, 59.
58, 59. Have you introduced this grandfather of yours?
Grandfather of the petitioner is, paternal grandfather is Nazim.
No, this DW2, he says that he is your grandfather. Now, please tell me, is his name there in your written statement?
Petitioner is the nephew, is the daughter of his nephew, your lordship.
I don't know. If I've read that correctly, it says, it first says that the proceedee is my granddaughter.
Granddaughter.
I am her grandfather, something he says like that. And then he says that she is the daughter of my nephew. Correct?
Your lordship.
That is something stated. In your written statement, have you introduced him to be your grandfather? Is any document there of your
Gaburas-
DW2 along with your parents?
No, my lord, it is separate house, your lordship. He lives in separate house. Grandfather is in separate house.
No, we are just examining. You see, the purpose is to understand that he's your relative.
Your lordship.
So how do you find that? How we
Gabura
connect
certificate, Gabura certificate is there, your lordship.
Page?
Exhibit 1, your lordship.
page?
Page 56, your lordship. 56,
56.
57. Fifty-seven is in Barnacle.
Just one. Which page? I'm sorry.
Page 57, your lordship. Annexure
57.
14A, Barnacle.
But this becomes inadmissible because of
Emblem.
state emblem. But did this person come and depose?
No,
The Gambura, did he come and depose?
no, your lordship has not come. My lord. My lord.
In your cross-examination, you have demolished your entire case.
My lord.
Are you aware what has happened?
DW,
Your-
your lordship,
Your cross-examination, DW1
DW1.
has demolished the entire case. You say that your father died in 2015,
15,
correct?
yes.
And in cross-examination, you say that your father is alive.
Cross-examination is,
So if your father is alive, then whose voter list you used?
my lord.
You demolished the entire
I-
case. That's why we are asking all these supplementary questions. Come to page 61 that we are referring to, your cross-examination.
My lord, cross-examination was done in 25/6 of 13, your lordship. Your lordship, can you see the date, your lord? 25/6 of 13,
Okay,
2013.
okay.
Her
okay.
father died in 2015, your lordship.
2015, okay.
Now what?
Item 13.
Are we the same? Are we the same? Congratulations.
Please, your lordship. Lordship, the review petition, your lordship, against which order this review petition has been prepared at page number 62, your lordship. Sixty-two starts from 62, your lordship.
What is the error apparent in this order?
Lordship.
What is the error apparent in this order?
Yes, your lordship. Your lordship, kindly see the page number 64, your lordship. The very relevant part has been recorded in paragraph number 5, your lordship. We have gone
64.
through the judgment of the learned tribunal. The judgment was passed on 165, and this petition has been filed in the year 2019. That delay part, your lordship, basically the delay part has been considered. And one more thing is that the petitioner has not adduced any evidences before the tribunal, your lordship. Considering that advance, your lordship, that earlier petition has been rejected, your lordship. Earlier prayer has been rejected. Your lordship, my sole ground, your lordship, to prefer this review petition is that, your lordship, due to the non-recording of my version, your lordship, in the earlier petition by the engaged counsel, your lordship. Unfortunate part is that, your lordship, on that ground, your lordship. And one more thing is that, your lordship, at that time, it was a IMDT proceeding.
Please elaborate. We have not been able to follow it. What is, please elaborate what you have submitted. Please elaborate what you have submitted.
Yes, your lordship. Your lordship, if your lordship kindly see the earlier writ petition, your lordship,
Yes.
against which, your lordship, this judgment has been declared, passed, your lordship.
Yes.
Dated, your lordship, 24 January 2020, your lordship. So
Yes.
Your Lordship, in the earlier writ petition, Your Lordship, the petitioner conveyed his instruction, Your Lordship, to the council, Your Lordship, earlier, that why he has delayed, Your Lordship, to prefer this petition, Your Lordship, because it was a case of IMDT, Your Lordship, passed in the year of Your Lordship 2000.
You see, you have the liberty of referring to the lawyer's counsel, but
Lord-
we don't have that liberty. We'll have to call him learned counsel.
Lordship,
Unless you demolish that learned part of it.
my apology, Your Lordship. What happened, Your Lordship? Because my only ground, Your Lordship. Otherwise, nothing is there, Your Lordship. Nothing so wrong, Your Lordship. Because lots of technicalities is there, Your Lordship, which is not even ever to the layman, Your Lordship, to those people, Your Lordship. Those
What was your
technicalities, yes,
instruction to
Lordship.
your counsel?
So, Lordship, my sole ground, Your Lordship, to prefer this review petition, Your Lordship, only that, Your Lordship. My part of the version has not been recorded in the earlier writ petition, for which, Your Lordship, the earlier order has been passed against me, Your Lordship. And relying on that, Your Lordship, I have pleaded one judgment of Honorable this court, Your Lordship.
You know what is the difficulty?
Lordship.
Show you this. Come to. It's okay.
Otherwise, the petitioning is out of retention here.
It's
To my knowledge. Okay.
Whatever is the concern declined perfectly to understand them.
Otherwise, worship. Yes, 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 yes.
That is normally the rule that is followed, my lord. Actually, what happens nowadays, when we type out this sort of affidavits, my lord, we take pains to see that these spaces and all, these are maintained in such a manner that these signature appears just below this portion, my lord, so that at least we can be shown, my lord, that he is aware and it was not a pre-signed, my lord, blank piece of paper. Now, my lord, that is also a concept of AI, my lord. The AI has to tell, my lord, the chat GPT has to come in and then only people learn, my lord. That is not the thing, my lord, because somebody today, they do not know that at some point of time when your lordship was on this side, you spend around 72 hours, my lord, cross-examining it, my lord, witness, and thereafter he lifted his head and saying that I do not know anything. So that experience does not go away, my lord. Being of that orthodox school from where we belong, that always remains, my lord. My lord. My lord. My lord.
Your lordship, other than that ground, to be very honest, your lordship, there is no infirmity in the earlier order, your lordship. And one more thing, your lordship, the earlier case at IMDT, the whole proceeding has been initiated under IMDT Act, your lordship. So that part is also there, your lordship. If lordship, I could got a chance, your lordship, to prove my case. I have all the relevant documents to prove my case in favor of my Indian citizenship, your lordship. So that part is also there, your lordship. Otherwise, the infirmity, if lordship kindly find the infirmity. Other than that, lordship, I have to be very honest, not other ground, your lordship, other than this, your lordship. So for that, your lordship, I have relied on to judgment of Honorable this court, your lordship, and Honorable Odisha High Court, your lordship.
Can you tell us what are the documents you think you have left out?
Yes, your lordship. Your lordship, 24, your lordship, page number. The father of the petitioner casted vote, your lordship, in the year 1965, your lordship. That is page number 24, your lordship. Type copy, your lordship. Annex the 2 series, your lordship. You know, it's
Just a
1970 vote.
moment, the opinion is at page 46, correct?
46, your lordship.
No, sorry, the opinion is dated 24/10/19,
Lordship.
correct?
Yes, your lordship.
No, no.
No, it was not my opinion, your lordship. It is the opinion is at page number, your lordship. That is my siblings' opinion, your lordship, whereby they have been declared as Indian, your lordship. That I have relied on, your lordship. Otherwise, the final order is at page number 60, your lordship. It was dated 1/6/2005, your lordship.
Is 60.
Lordship. It's not quite legible, your lordship. The type copy is at page number 58, your lordship.
In the review petition, what is the statement made as to why why the petitioner did not contest? What is the reason?
Yes, your lordship. What happened, your lordship, in the year of 2002, your lordship, I have put this things. The ounces there, your lordship, starts from your lordship. Page number 15, start from page number 15, your lordship. Because your lordship, mistakenly what happened in the year of 2002, your lordship, my youngest counsel, the who pleaded my case in the tribunal, your lordship, got expired, your lordship. After that, your lordship, I appeared before the tribunal for 4 years, since 1999 till 2002, your lordship. Yes, I admit, your lordship, after that, I was absent before the tribunal, your lordship. But it was a my mistaken of fact, your lordship, that I thought, your lordship, the case was end up, your lordship. The case is closed, your lordship. So, lordship, it was some error. I think it was mistaken fact on the part of the petitioner, your lordship. He did not appear. That is true, your lordship. It is true. For that reason, your lordship, I have been declared as a foreigner, your lordship, illegal migrants, your lordship. So that part, your lordship, after that, what happened, your lordship? The petitioner has been thrown to the detention camp, your lordship. At that time only, this petition has been preferred, your lordship. This writ petition, your lordship. The earlier writ petition has been preferred, your lordship, after a lapse of few years, your lordship. So on that ground, your lordship, the earlier writ petition has been rejected because of the delay, your lordship, and because of non-submission of my documents, your lordship, before the tribunal, your lordship. Otherwise, I have handed over my documents, your lordship, that is reflected in the WS itself, your lordship, before the tribunal. But the original, I have, that part has been lapsed, your lordship.
And you say that this lawyer expired.
Expired.
After expired, she
2000
appeared, Lordship.
2000.
After expired, she appeared before the tribunal, Lordship.
No,
But the fault is on whose part?
lordship.
If it's a fault on part of the lawyer who has expired,
No, that,
obviously after death, we can't ask him any question.
no, lordship. So I never arrayed him as a party in this petition, your lordship, even earlier petition also, your
It's
lordship.
not a party.
No, not a party, because he died in the year 2002.
No,
your
you
lordship.
see that you can't be excused even if your lawyer was at fault. Have you checked up page 60? What do you call this?
Yes, your lordship.
Your type copy at page 65.
'65, your lordship.
Yes. 15/2/99 issue notice. 25/3/99 notice written after service ex parte order.
Yes.
5/5/1999 OP placed to set aside
Yes,
ex parte order and placed to accept the written statement It was accepted,
Yes, Lordship.
and after then, I just lost count. I couldn't count.
No,
How many
Lordship,
adjournments
Lordship,
taken?
I catch it, your Lordship. I catch it, your Lordship.
So you are already treated with pure leniency. The tribunal was not in a hurry,
Not in hurry, your Lordship.
and then you, somewhere in your writ petition, you have made a statement.
Lordship.
I'll not be able to tell you where. You said that you were in a mistaken belief that the case would be. You have said about some mistaken belief
Lordship.
that this case would be over.
Yes, yes, Lordship. I have pleaded, Lordship.
Where is that statement made? Ah, yes, page 15.
Yes, Lordship.
Page 15
Lordship.
counts.
Lordship.
You said that petitioner mistakenly thought, and next page it carries forward to page 16. He mistakenly thought that his case might be end up, and he did not appear before the tribunal anymore.
Yes, yes, Lordship.
Now, can we, in the face of this statement, condone it?
Lordship.
On the face of this statement,
Lordship.
can we condone? I don't think so. No, we are sorry. You've given 4 years of adjournment.
Yes, yes, Lordship.
In Lordship, those pleas are not taken in the repetition also.
No, that's okay. They say that the lawyer was at fault. We're trying to understand what is the fault. Those are not there. But still, the cases of citizenship, even if we find out smallest way to accept that
Yeah.
projection. But here, no. You're relying on this. In fact, both of us, we are searching for a lawyer. I have said this statement in many times in this court. I think more than 100 times I have said, we are also searching for a lawyer to whom you can give documents and then you think that case is over. No, not for anything else, because that could be a case study. For us, being slightly connected with academics, need it for a case study. And if one lawyer can give that amount of what you call enthusiasm with a party, that giving the documents would give them the relief. Sorry. Advocate, what we can't accept. Heard. Is G. Bora, learned counsel for the petitioner, and so for the respondents. Next, by filing this. Oh, Mr. Sharma, we have not heard you. Yes, what do you have to say?
Lordship,
You
my
accept-
simple submission is that Lordship, there is no error apparent on the face of the order, Lordship, passed by Honorable High Court, Lordship, and Lordship, order is very much clear, Lordship. Para 5 and 6, Lordship.
Okay.
We have gone through the judgment of the learned tribunal. The judgment was passed on 1/6/2005 and this writ petition has been filed in the year 2019. Furthermore, the petitioner did not adduce any evidence before the learned tribunal. The impugned judgment reflects this fact, which stated that even after being given ample opportunities to adduce evidence, the petitioner did not adduce any evidence before the learned tribunal. Now, when the petitioner was arrested and put into detention camp, then only filed this writ petition, Lordship. So it is clear on the face of the record that there was utter negligence on the part of the petitioner. The petitioner did not exercise due diligence. Then para 6 is more important, Lordship. A writ court exercising powers under Article 226 of the Constitution of India would not review the finding of facts. The writ court's power is supervisory only just to make sure that no perversity is done by the learned tribunal. Here there is none. Therefore, we find no merit in the writ petition and accordingly same is dismissed. And
So you are supporting this
yes, Lord.
and so for the respondents. Next one. This review petition is directed against the judgment and order dated 24 January 2020, passed by this court in WPC 7099 of 2019, thereby declining to interfere with the ex parte opinion dated 1/6/2005, passed by the learned member, Illegal Migrants Determination Tribunal, Nagaon. This page 60. In IMDT, I within bracket D, bracket close T, case number 320/98 within bracket capital D. Struck by the said opinion, the learned tribunal had held that the petitioner is an illegal migrant under section 3 within bracket 1 within bracket small c of the erstwhile illegal migrants within bracket determination by tribunals bracket close act 1983. Next. The said final, the said opinion of the IM within bracket D, bracket close T, Nagaon, was assailed by the petitioner before this court by filing WBC 7099 of 2019. And as stated above, the petition was dismissed. Next paragraph. The learned counsel for the petitioner, by referring to the contents of the review petition and the grounds on which this review petition has been filed, has submitted that the petitioner has several documents from which he could demonstrate that his father was the voter as per the voters list of 1970. And that the petitioner has an HSLC examination admit card for the year 1996, which would establish his linkage with his father. Stop. In this regard, it is submitted that the petitioner had provided all the documents to his learned counsel, but the same was not submitted before the tribunal. Stop. Moreover, it is submitted that the petitioner was never instructed by his learned counsel to give evidence or to produce witnesses to establish his defense. Next para, it is further submitted that if the petitioner, as the petitioner has in his custody the voters list of 1970 of his father and his admit card for the HSLC examination, 1996, there was no reason not to provide the documents to engaged counsel, to his engaged counsel. But none of those documents were filed before the learned tribunal, and no instructions was provided to the petitioner to deed evidence in the case. Full stop. In support of the submissions that for the fault of the advocate or the petitioner should not suffer, the learned counsel for the petitioner has cited the case of State of Assam versus Ganesh Mal, GANESH MAL, Maheshwari, MAHESWARI, comma, within bracket 1992, bracket close 1 GLR 146, and Lakshmidhar Das, LAXMIDHER, Lakshmidhar Das versus State of Odisha and others, comma, within bracket 2014, bracket closed, Supreme, within bracket Odisha, ORI, bracket closed, 390. To impress upon the court that preventing of miscarriage of justice is a permissible ground for review, and the negligence on part of the learned counsel in presenting the parties parties version may warrant a review of the judgment. Next para. per contra, the learned standing counsel for the FT and border matters has made his submissions in support of the order dated 24 January 2020, passed by this court in WPC 7099 of 2019. And in support of the impugned, in support of the not impugned, opinion dated 1/6/2005, passed by the IM within bracket D, brackets T, Nagaon. Next para. On a perusal of the materials available on record, we take notice of the fact that in the proceedings of IM within bracket D, bracket plus T, case number 320 of 98, within bracket D, bracket closed, notice to the petitioner was issued by order dated 15/2/1999. And as the petitioner did not appear by order dated 25/3/1999, case was fixed by ex parte hearing. However, on appearance of the petitioner, by order dated 5/9/1999, the ex parte, the order to proceed ex parte was set aside. 5/5/1999. The order to proceed ex parte against the petitioner was recalled, and the written statement was accepted. Full stop. It appears that thereafter that the matter was adjourned on 37 or not? On 37 occasions between 25/7/1999 and 6/4/2005, and by order dated 6/4/2005, case was fixed for final argument, which was heard by the order dated 28/4/2005, and thereafter the impugned opinion was passed on 1/6/2005. Next. Next, the learned counsel for the petitioner had submitted that in the writ petition, a proper presentation, that the relevant instructions were made available to the learned counsel engaged before the learned tribunal, was not clearly indicated, for which the petitioner has suffered irreparable prejudice. So accordingly, I think something that that not only the petitioner's case before the tribunal could not be projected. But even in this code, the correct state of affairs was not disclosed. Next para, accordingly, it appears that the main thrust of the petitioner in this review petition is that the instructions as provided to the Learned Counsel for the petitioner before the IMDT, as well as before this court, in connection with the writ petition, were not properly presented. Next. Para. The court is unable to accept the contention as presented by the Learned Counsel for the petitioner on the ground that the statements made in the writ petition is supported by an affidavit and the said affidavit in support of the writ petition contains an endorsement by the notary public that certifying that he had read over and explained that the notary, don't say he or she, I can't find out, that the notary had read over and explained the contents to the declarant and that the declarant seemed to perfectly understand them. Next paragraph. Resultantly, if the contents of the writ petition was read out to the petitioner and she had accepted that she had understood, accepted before the notary public that she had understood, that he had understood the contents, in the considered opinion of the court, would not constitute a good ground for interference with the order under review. Full stop. In the next, in the proceedings before the Learned Tribunal, moreover, it is not the case of the petitioner that before the Learned Tribunal, she had got the affidavit, she had been presenting himself as witness before the Learned Tribunal. Rather, it is observed that in most of the dates, the petitioner was absent. Accordingly, it cannot be accepted that that merely because documents were provided to the Learned Counsel, he could lead evidence on behalf of the petitioner even when the petitioner was absent. Next, resultantly, we find no ground to hold that for any reason whatsoever, the order of this court dated 24/1/2020, passed in WBC 7099 of 2019, is vitiated for any reason whatsoever. In light of the prescription of section 114 read with order 47, rule 1 of the Civil Procedure Code. Next para. Next para. In the case of Ganeshmal Maheshwari within bracket Supra, all the facts are distinguishable because the writ petition was heard in the absence of the government advocate, and the reserved judgment was delivered on 1991. Full stop. However, the state in the review application, could demonstrate that the Paravis comments were made available to the Office of the Senior Government Advocate, and according to this court accepted that the version of the state was not presented due to lapse in the Office of the Senior Government Advocate. Full stop. In this case, the petitioner was required to appear during the trial of the proceedings before the IM within bracket D, bracket was T. And as the record reveals that petitioner was absent on most of the dates, the ratio of the case of so and so cannot be attracted in the present case in hand. Next paragraph. For the same reason, the decision in the case of Lakshmidhar Das, LAXMIDHAR, Lakshmidhar Das, within bracket Supra, also not be attracted, as the petitioner has failed to demonstrate the fault on part of the advocate in conducting the case before the learned tribunal. So rather, the tribunal had been very liberal in granting adjournments in the present case, thereby giving more than 4 years' time to the petitioner to lead evidence. But the same was neglected by the opportunity so granted was neglected by the learned by the petitioner. Next para. Resultantly, we don't. The court is of the constituted opinion that no grounds are made out for interference with the order of this court dated 24 January 2020, passed in WPC 7099 of 2019. Next. The review petition is found devoid of any merit and therefore, dismissed. There shall be no orders to cost. Next para, the registry shall, no, the learned standing counsel for the Home Department shall transmit a copy of the report to the Home and Political Bureau Department, so as to transfer the same to the concerned tribunal having the records.
There is an ILO.
Huh?
I cleared out.
I closed.
Blessed.
Yes, we have item 14.
Great, please, your lordship. Lordship, the previous set of advocates have returned the brief to the petitioner, and we received the petition from the petitioner today morning, and as such, we haven't had the time to file the wakalatnama. So, lordship may kindly adjourn the matter. It can be heard next week, lordship. I'm appearing on behalf of A.W. Aman.
Okay, both sides represented, convicted eligible and constable petitioner. The matter is adjourned today. Please list on 7/11/2025.
I'm deeply obliged, your lordship.
Item 16.
May I please, your lordship, kindly pass over the matter for the time being.
Time being. Okay. Kindly. Seventeen.
May I please your lordship? Lordship, I'm appearing on behalf of engaged counsel, Mr. Jed Khalid. Lordship, the state had filed affidavit on opposition. We will be filing a counter affidavit in reply to that affidavit in opposition. Lordship may kindly grant 2 weeks time for the same.
Miss, your name,
Farhin Farid.
just write it down. Write it down, we may make a mistake. So, the counsel for the petitioner prays for and is granted 2 weeks' time to file affidavit in reply in the matter. State is represented by Mr. S.K. Hazarika and the committee. List on,
Obliged, Lordship.
give a date after 2 weeks.
Obliged.
Yes, item 18. Yes,
Lordship, in the last petition had asked the parties to be present to explore the possibilities of mediation election. The party, the petitioner is here, sir.
My client is present through VC.
yes, can you please step forward? The respondent is appearing through video conferencing, yes? You are Arvind Kumar Khemka.
My lord, yes, sir.
You see, this being a matrimonial dispute,
Yes, sir.
we want both of you to be present before the mediation center so as to make an attempt of settling all your disputes.
Sir, am I able to explain something, sir?
Yes, and did you have the access to the child?
Yes.
You had the access to the child. Yes, what do you have to say?
Sir, like we have already initiated so many attempts to go for mediation and settle the things. But what happened after mediation? So many cases has been added in multiple places through police station and through different courts. Just in this Diwali also, she added one police case in Varanasi, and she reopened many other cases which has already been FRT has been given. Like in Calcutta, 160 notice I have been got from Karaya police station, and then same call from Varanasi police station that she has filed some cases on the time of Diwali. So this mediation, if you sir, if you are okay with that, you can see all the matters together, like all the police matter, all the legal cases together.
Did you hear us when I was making this statement? Did you hear it?
Pardon, please, sir.
When the court was making a statement, did you hear it?
Sir, which statement right now, sir?
Yes, right now we made a statement. Before that, we never interacted. This time we
Okay.
made a statement. We told you that we want you to come here before the mediation center to settle all your disputes.
Okay, sir.
All your disputes would include each and every dispute. Maybe there are 20 cases between you two. But
Okay,
you have
sir.
to make an attempt for the settlement of all the cases. You see, we have got you into video conferencing and in physical appearance
Okay, sir.
to make you understand that once you go for a mediation in disputes which are family matters,
Okay, sir.
we have had experience of wonderful results. And and one of the good things is that if all the disputes get settled,
Yes, sir.
then perhaps both of you will be in a win-win situation, unless both of you have any of you two have an interest in prolonging the litigation. Some people have an interest in prolonging litigation. If that
Yes,
is
sir.
not the interest of you as the second party and to you, Mrs. Meghna Khemka, then perhaps you can both give consent for the mediation. Please suggest a date because
Item 20.
May it please the Lordship, as per the last order, we have submitted the postal track record and notices have been delivered, Lordship, to all the respondents.
I'm appealing on the final.
Lordship, in total, there are 12 respondents,
you are paying for all.
30.
No, my lord, to the private respondent only. My lord, there is a official respondent is that 11, 12 and 13.
Okay, private respondent numbers 1 to
1 to 10 lordship.
1 to 10. Okay.
Yes, lordship. My lord, except my lord 5 and 7, my lord, my instructions, my lord, there are no more, my lord.
Hmm?
There are no more, my lord. There.
5 and 7.
5 and 7, my lord. Vishwakush and Lila Kush.
5 and 7.
Yes, lordship.
Yes. If they are not there, how did you serve it?
Yes.
Lordship, someone, Lordship collected the notice because Lordship, from the postal track record, it says the
but-
notice has been delivered.
Yes,
Have to take his
we can appear on the legally.
for a dead person.
No, my lord, on behalf of their legal, but they have to serve to the.
No, that's okay. But if somebody is dead, you'll have to,
Yes, lordship.
because otherwise your repetition, this review, this,
Their wife is dead.
I would abate.
Lordship, we can take the details and amend the cost title, Lordship, in that
No,
case.
do it, but you first take note whether they have died or not.
Lordship.
He can't say for sure.
Yes.
Ms. P. Barwar and counsel for the applicant is present and submits that notice was served on the respondents, the private respondents through Dusty mode
Lordship, no, Lordship, through usual, Lordship,
Huh?
through postal mode, Lordship,
to post,
post.
through post. And the postal track reports have been submitted before the registry. which is tagged with the record. Next para, Mr.
D. Gogol.
D. Gogoi, learned counsel, appears for the private respondent numbers 1 to 4,
5.
comma 6,
8, 9, and 10.
and 8 to 10.
8 to 10.
And to the prayer, you have any objection?
Lordship, for delay. Delay, Lordship, we file an objection.
You file objection. And he prays for some time, prays for and granted 2 weeks time to file affidavit in opposition in the matter. Next para. The learned counsel for the private respondents has submitted that as per information received by him, comma, the respondent numbers 5 and 7
Look.
have expired. So stop. Next para, the learned counsel for the applicants. Seek some time to take instructions and take appropriate steps. Matter stands adjourned today. List, we're giving 2 weeks time, give a date after 2 weeks. 2 weeks is okay?
Lordship.
12, 11.
Lordship, my lord, the application may be punished to me, my lord, because the application, some pages are missing.
Huh?
Some pages are missing, my lord.
Lordship and furnished.
Pages are missing. Give it,
Lordship.
Lordship.
take it from,
Lordship.
give it a fresh, give me a
Oh,
fresh copy.
Deeply obliged.
Deeply obliged.
Item 21.
May it please your lordship. Here, as per the order dated 19/9/2025, there was a order to take steps on respondent. There was an order to take steps on respondent two by Dusty Service. Now the notices of Dusty we have received only on 15/10 and 16/10/2025. So therefore, some more time may be granted so that we can file the affidavit. We have not received, we have received it from the section, we have sent it to the client. Now they will take the signatures and they'll send the notices. Yes, and
I'm appearing in your name, on behalf of my lord.
for 1 and 2. 1 and 3.
1 and 3.
It can be fixed after 2 weeks. In the meantime, I'll file the affidavit. On respondent two, the BVFCL.
Brahmaputra Valley Pathway. Yes, Bhattacharya. Bhattacharya. CGC, madam. No. 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 No.
In the next item also, your lordship, there is a delay of 18 days. Similar order can be passed there. Yes, sir. 22. Obliged.
Obliged.
Item 23.
My lord, pursuant to the directions of this court, we had filed an affidavit, my lord. But even though we had filed an affidavit, Well, I'd not like to say anything on the merits of the entire thing, my lord. Even except the fact that, my lord, there was some amount of negligence on my part, my lord. Because if we go to the Notaries Act and, my lord, sections 8, 11, and 13, some duties are cast upon us, my lord, and due to inadvertence, my lord, it happened that, my lord, I did not insist upon that deponent to sign in my presence, my lord. That was an, my lord, inadvertence, and I have learnt a lesson, my lord, and I seek the forgiveness of this court, my lord. Otherwise, apart from that, there was no other intention to, my lord, misrepresent before this honorable court, my lord, or to, my lord, cause any disturbance in the administration of justice, my lord. That is my humble prayer, my lord.
ভৰাব খোজা নাই কিন্তু দুয়োজনে একেলগে উকিলজনক ব্লেম কৰিছে না উকিলজনৰ সেইটো কি সেইটো মানে মই চালো বস্তু দুটা পেয়াৰৰ একে বস্তুটো সেইটো হয় নেকি
My lord.
কণ্টেম নহয় কিছুমান নাই নাই
My lord. And that's why I said at the very outset, not even though, my lord, but we don't, my lord, like to, my lord, press on that, my lord, that's why, my lord. My lord. My lord. My lord.
Actually, I'm always available, but only my lord, some adjustment is required.
Yes, my lord.
My lord.
But let it be on the, my lord, 12th of November, my lord,
Maybe 31,
or maybe
31,
31st of October,
31.
October. Or let it be 31st of October, 31st. Three. Hello, the name of the movie was Andaz. The name of the movie was Andaz. Rajesh Khanna, Shammi Kapoor, and my lord, Sharmila Tagore.
Very difficult.
My lord. No, I understand, my lord. I understand because I was following, my lord. And in fact, my lord, lordships, both of us now we are on orphan, my lord. So, my lord, I also got back to the memories of my parents, my lord.
Nobody losing, only the child is the losing everything.
Yes. Yes.
Child losing mother's love, father's love, everything. He is my lord.
My lord,
Without his fault, my lord. His or her.
very, very, very difficult, my lord. Today, my lord, egos crop up in such a manner, my lord, nobody is even willing to take one step backwards, my lord. That to solve it even in the interest of the child. No, I know, my lord. But even then, my lord, today, there was a list, my lord, which has been circulating in the WhatsApp. It says, my lord, the rate of divorce amongst the entire world, my lord, Portugal, the rate of divorce in the entire world, Portugal tops the list. And India is at with 1% only. It is at the, India is the last country down the list, my lord, with only 1% of cases being, my lord, divorce being granted.
But in those countries, my lord, is a very common practice. My lord, that is nobody bothered.
At least
It's a very
here-
easy.
Here we are. Some
But
amount
here,
of
my lord, it is
sanity
not
we
so.
are- Some amount of sanity we are maintaining, my lord.
But 12.3%.
High.
In other countries,
Yes,
my lord,
yes.
we cannot compare it. My lord, these are, my lord, very common.
Very difficult, my lord.
Elizabeth Taylor.
My lord. My lord.
Elizabeth Taylor 7 বার বিয়া করেছিল।
Oh.
Typhus করে।
আঙ্গাতে বলি হবে কেউ।
Seventh husband was the same husband who was first time.
দম পালে মানে ঘুরে ঘুরে। My lord. My lord. The meaning of this is, my lord, that is what I have stated. In my lord, sections 8, 11, and 13 of the my lord Notaries Act, my lord, certain rules of procedures to be followed by the notary has been laid down, my lord, and my lord, on the basis of those rules and procedures, my lord, there are certain judgments, my lord. And my lord, in view of the fact that has happened, it is, my lord, clear that I was, my lord, to certain extent, my lord, I lost my cautiousness. I had to be more cautious. I was a little bit less cautious, my lord. I have admitted that. Now, the fact is that, my lord, prior to filing of this affidavit before the court, my lord, I replied to the show cause. My lord. My lord. No.
Yes.
Yes. No, my lord, that is the law, my lord. And my lord, the law is that when, my lord, it is proved and shown that the deponent is not there before the notary, then that act of that notarial act itself becomes void, my lord. There are
There is no
judgments to that
meaning
effect.
at
I
all.
was-
There is no meaning at all.
No meaning at all. And
Is that if the law does not prescribe the negative,
my lord,
then you must give a positive statement in your writ petition that no, without a deponent, I will not sign.
yes,
That is not there. You say that I'll exercise my duties not beyond the procedure prescribed.
my lord.
But procedure
Because
prescribed
I
does
had
not
already,
say.
because my lord, I have already committed that. And now, my lord, this, my lord, this law is, my lord, that is the latest law laid down by the Supreme Court in 2020, my lord. That says, my lord, specific statutory provisions such as sections 85 and 57 of the Evidence Act presume the authenticity of deeds notarized properly, but this presumption can be challenged if procedural lapses are evident.
No, no, we are
Now,
not on that part.
yes,
No,
my
we are
lord.
not on that part. You see,
My
we
lord.
have very specific query.
My lord.
Law does not prescribe the negative.
No, it does not.
Then where is the positive statement that I will not execute a affidavit without the deponent? That statement is not there.
I have, in paragraph 10, my lord, not in so many words, but this is what I have stated, that I undertake to be cautious in future, shall not exercise my duties beyond the procedure specified under relevant laws and shall strictly follow the rules made thereunder.
But beyond the prescribed, you see, that means you are still having roaming free.
No, I am not roaming free, my lord. I am binding myself that whatever is the rule, my lord, I will go by that, and beyond that, I will never step even one step, my lord, anywhere else. This is what I intended to say, my lord. But it may not be in so many, my lord, clear words, but I have mean only that, my lord.
I will never do it
Oh.
again. It will be better that I will never do it again.
Positive statement, you see, what
My
happens
lord.
is that that's why you showed you that last.
I have, yes, my lord,
And you see, we have to dismiss it.
my lord. My lord, with all humility in my command, my lord, I have stated, but this is the meaning I have stated, my lord, that I will strictly follow the rules and fair, my lord. I'll strictly follow, my lord. I'll never, my lord, step even once,
Okay, we'll
my
take
lord.
it up next week.
My lord,
You want it on 3-0, we'll take it
my
up.
lord, on 30th.
Both sides as represented. Just give the name. Head Mr. T.J. Mahtal and his senior counsel. And Lawrence Strategic Counsel for this court, assisted by Ms. P. Sharma, Learned Counsel. Also had Mr. J. Avidin, Learned Counsel for the you are number 1 here.
My lord.
For K. Rahman, as well as Mr. G. Chaudhary, Learned Counsel appearing for Mr. A. Kudus.
Mohan, judge.
Next part. If you will reply, the affidavit.
My lord, for K. Rahman, Joinul appears, my lord.
Oh, that's what I said.
Yes, my lord.
That's what I said, K. Rahman. So procedure filed the affidavit. Accordingly, list the matter again on 30/10/2025.
I'm due to.
What? Item 16, nobody is there. Wait now.